Today is 11 July 2026. I am making this video to let you aware of the mails. 11 July 2022 to make you aware of the mails which I am mailing all these years to the Supreme Court and also to the AP High Court. Actually, whenever a private company accident means a private party versus victims, or the industrial disaster contains both injured and deceased category, which are very important. Both components are treated as victims. These all of us are aware of. When applying the polluter pays principle, whenever there is an accident, the SDRF, NDRF and state police will advise the factory to open a hospital or a treatment facility. It should be made available by the factory at their own cost for emergency care also. But when it comes to the LG gas leak issue, case 112 of 2020, court directed the government to open private hospitals and private government, not the factory. And also the disaster management, also they directed to respond. 7 May 2020 court order. APLSA and DLS is also informed to provide legal aid to the victims of classified industrial major mass disaster. Industrial disaster. In this scenario, when the factory is a third party private person, the accident done by the accused negligence, absolute liabilities for loss of life lies on the polluter, which everyone is aware of. Along with loss of life, injuries are also important. When applied MSIHC rules, Manufacture Storage Import Hazardous Rules 1989, affected population, leakage of hazardous chemical from a storage tank and affecting the environment. MSIHC rules 1989 means affected population is also important. Then what the government laid some protocols for treatment and handling of hazardous chemicals. All the law should be applied on the factory whose negligence is cause of accident. Okay. At this scenario, though government provided assistance from the relief fund, which is financial assistance, is no mean to say that it is compensation for an accident done by LG Palmer company. Here, adjacent to that, taken up sumoto on public interest case 112 of 2020. Though proper filings are made with the High Court, 117 Supreme Court guideline mortal damage to the deceased, and also 119 Public Insurance Liability Act, GORT 449 is a release of funds from CM Relief Fund, Chief Minister Relief Fund, allowing the government to declare whatever amounts they want to give to the victims on public interest only. That also means for the welfare of the public, the government relief funds are there as per SDRF norms. The CM relief fund norms on which the crowdfunding is collected from the public is only for helping the people or for the welfare of the people involved in notified natural calamities. For this accident, they released funds, disaster management response to an immediate response. They released funds from the CMRF. In that also, only death were given fair payments ex gratia from the head of the relief fund. So this relief fund is also relevant to the factory where when applied a polluter pays principle, the cost of restoration of environment and compensation on the polluter. That emergency care with lot of advices in the medical reports and schedule of monitoring as released by the government for 5 years, treated as epidemiology studies, which requires a hospital to be set up in 2020 May itself to treat the victims. And data analysis may extent of damage to health to the victims. Long-term health loss and long-term loss of life of the affected and injured population. Victims should recover well. Material congestion will be there in the body. People developed abnormal swellings at different locations on the body. People have organs damaged. The GO mentioned only ventilator cases and all other people are given 25,000, 75,000 from the and 10,000 for staying 5 days in the shelter camp away from their homes. Here when filing with that High Court, all the filings are done already, including government played a submission on 6 April 2021 when court failed to direct LG Palmer to deposit adequate amounts with the district magistrate, 147 of 2020 contains 500 crores deposit should be made towards cost of registration of environment and compensating to the victims under polluter pays principle. The government failed to provide treatment expenditure to PV Sudhakar only to set up a hospital with 24 hours monitoring and recruitment of doctor, drugs and disposable DNA isolation kits. Reproductive health loss, people who lost their reproductive health, people who died in that 5 years monitoring period also should be considered. The actual loss of life in Bhopal gas leak is 2000 to 3000, but through monitoring schedule it is available in the ICMR website. It is around 22,000 died overall loss of life. Like that, for toxication and inhalation of toxic chemicals, the overall loss of life is different from immediate deaths. Long-term loss to humans is clearly mentioned in 147 of 2020. So all filings are made. During material sales also the government letter submitted. Why there is no court order directing LG Palmer so that the deposits available with the district magistrate be disposed to the victims. Identity cards not issued to the injured population to avail legal aid services with that APLSA, DLSA and Supreme Court legal. Now we are providing medical reports as evidence to provide so that they can provide legal aid. With no reason, the APLSA used to send all my legal aid application to the district court. They accepted and done in the district court. Supreme Court also accepted Section 12 of NALSA Act. They taken up cases Sumoto Pill, where they taken up the case on public interest. Victims were allowed to file as respondent in the public interest litigation taken up by the High Court under Section 12 of NALSA Act. The acts and rules placed are allowing the victims of mass industrial accident to file with the High Court. They unnecessarily closing my applications without any reason, valid reason, taking into account that NALSA Act, which is laid by the government of India, where all the Nyaya Sadans in India will work on those acts laid in NALSA Act 1987. Recently also I received a copy from High Court of Andhra Pradesh stating that I can't file public interest. I am not at all filing any public interest. As a victim, the High Court of Andhra Pradesh has to form a redressal committee to redress the issues of the victims. But independently, when I am out of my own cost, I am sending all documents to the High Court Nyaya Sadan and also affidavit notarized copies to them. Instead of appreciating my efforts in filing with the appropriate authority or moving the issue with the Chief Justice of Andhra Pradesh, a justice which is much delayed, they are returning my copies, saying that the case is seized on the other end from the Registrar General. On the other end from the AP State Legal Service Committee, they are rejecting to file the actual documents, accident data with the High Court. They never ordered the government to submit registration plans or witness data with the court, or never directed throughout the case LG Palmer to obey rule of law. Means they should accept the fact that it's an accident done by LG Palmer Company versus victims as an individual party, third party accident. All the compensations, whatever delivered by the private companies as per market values for the victims, means partial disability, permanent disability, and also that any sort of sickness derived out of accident be considered injured only. Though government classified only ventilator, there are plastic surgery, organs damage, severe injuries on internal organs, external patches. Different categories are there. Wounded people also there. Long-term suffered of permanent disability is myself. So, out of all the contests, when you are unable to understand the reason why I am mailing you every day, I am making this video to let you understand that we require justice and proper communication with the High Court to say that the proper justice be delivered, which is much delayed, in the form of a order directing LG Polymer so that the deposits be disposed and identity cards be issued. Continuous treatments until health recovery will be given, and also the present CS are concentrated on that medical component based on 6th point of NGT order. When they fail to establish a hospital and restoration of health, all the victims' families should be provided identity cards and health cards by the government, and the expenditure on medical bills shall be borne by the unit. Means medical bills for recovery of health, restoration of health, which is not funded by the government, be borne by the LG Polymer factory only. Based on the 6th point of NGT, they have given some aid to the affected families in the threat zone area, and rest of families more than 70% provided 50,000. Property damage also not assessed or paid to any of the houses nearby the factory where we lost our clothes and valuables and property being damaged during evacuation. Electronic gadgets also damaged and vehicles became shaded. Jai Hind.